Is the US government trying to expand the pool of people who can be stripped of citizenship? A new proposal in Congress called the Fraud Accountability Act has a lot of people asking exactly that question. The reason it's getting so much attention is that it would dramatically expand when denaturalization could happen, especially by tying it to fraud convictions that occur after what if someone has already become a US citizen. In this video, I'm going to walk you through what this bill is trying to do, how it's different from the way denaturalization works today, who it might affect if it ever became law, and some practical thoughts about what it could mean in the real world. I'll also explain why, even though the language of the bill sounds very aggressive, it's important to keep everything in perspective. A bill being introduced is not the same thing as a bill becoming law, and a bill becoming law is not the same thing as that law surviving constitutional challenges in court. You're watching Immigration Newsroom, Ounin, where we break down U.S. immigration and citizenship issues in clear, plain language. Nothing here is personal legal advice. I'm not your attorney, and I'm not speaking for any government agency. My goal is to help you understand what is being proposed so you can follow the news without unnecessary panic and know when it might actually be time to consult a qualified immigration lawyer about your specific situation. Let's start with how denaturalization works right now under current law because that's the baseline this bill is trying to change. Today, when people talk about denaturalization, they are almost always talking about something connected to the way citizenship was obtained in the first place. The classic scenario is this. Years after someone becomes a citizen, the government discovers that there was a serious lie or a major piece of information that was intentionally hidden during the immigration or naturalization process. That could be using a completely false identity, concealing a serious criminal conviction abroad, hiding involvement in human rights abuses, or lying about something that was central to eligibility. In that kind of situation, the government can argue that the person illegally procured citizenship or obtained it by willful misrepresentation of a material fact. Material means it mattered. If the truth had been known at the time, the person probably would have been denied. Denaturalization in those cases is not an extra punishment for something that happened later. It's more like saying you should never have been approved in the first place because you lied to get here, so we're canceling the approval. Even then, citizenship is not taken away overnight. The government normally brings a separate civil new case in federal court. The person is served with a lawsuit, they have the right to an attorney, they can respond, present evidence, and argue their side. A judge looks at the evidence and applies specific legal standards. Only if the court agrees that the government has met its burden can naturalization be revoked. It is a slow, formal, and relatively rare process. Crimes committed after one naturalization are generally handled in the normal criminal justice system. If a U.S. citizen commits bank fraud, tax fraud, healthcare fraud, or any other offense, they can be investigated, charged, convicted, sent to prison, ordered to pay restitution or fines, just like any other citizen. But under the normal framework, denaturalization is not simply added on top of those criminal penalties for conduct that happened long after citizenship was granted. The Fraud Accountability Act would change that concept in a very significant way. It was introduced in both the House and the Senate, and it appears to be a political response to a recent high-profile daycare fraud scandal. On paper, the bill is framed as being about punishing fraud and protecting taxpayers. But a very large part of the text talks specifically about immigration consequences, what happens to permanent residents and what happens to unnaturalized. U.S. citizens who are convicted of certain types of fraud. Here's the core idea that has people understandably worried. Under this bill, a naturalized U.S. citizen could be denaturalized. Why say? Because of fraud they committed after they became a citizen, even if that fraud had nothing to do with their original immigration case. That is a huge shift from the traditional rule that denaturalization is tied to fraud or ineligibility. During the path to citizenship, how does the bill try to make that happen? One of the biggest structural changes is that it would connect denaturalization directly to the criminal case itself. Instead of having a separate civil denaturalization lawsuit later, the same judge who handles the fraud conviction would be required to move straight into denaturalization if the offense fits the bill's definitions. In other words, once there is a qualifying fraud conviction, denaturalization is triggered as part of the sentencing and post-conviction process. And the language the bill uses is mandatory. It doesn't say the judge may denaturalize or has the option to denaturalize. It uses wording like, the court shall revoke the person's naturalization. In legal drafting, shall usually means there is no discretion. If the conviction fits the statute, the judge has to strip citizenship. There is no built-in room for leniency or weighing the person's history, family ties, or how long they've been a citizen. The bill also changes how fraud is treated in the immigration context. Under existing law, not every fraud-related crime is treated at the same level. For some of the harshest immigration consequences, including being labeled an aggravated felon, there is often a monetary threshold, commonly a loss to the victim of more than $10,000. That number shows up in various parts of immigration law and acts as a kind of dividing line between smaller-scale fraud and very serious financial crime. The Fraud Accountability Act removes that $10,000 threshold for certain consequences. It talks more broadly about fraud against individuals, companies, funds, or the government, without keeping that monetary floor. In practice, that means a much wider range of fraud convictions, potentially including cases with lower dollar amounts, could trigger removal for permanent residents and mandatory denaturalization for citizens. To see how this could play out, imagine two hypothetical people. One is a green card holder who runs a small business and is convicted in federal court of a relatively modest fraud scheme involving $5,000. Under current law, that might or might not meet the aggravated felony threshold, and the immigration consequences would depend heavily on the statute and loss amount. Under the proposed bill, the lack of a $10,000 floor could mean that conviction now clearly makes the person deportable. Now imagine a naturalized U.S. citizen in a similar situation, someone who became a citizen 10 years ago, now convicted of the same type of low-dollar fraud. Under normal rules, they would face the criminal penalties but keep their citizenship. Under this bill, the judge handling the criminal case could be required to also revoke that person's citizenship as part of the process, even though the fraud had nothing to do with how they originally immigrated. The bill tries to do this by changing and expanding definitions in Section 237A, Title 2, of the Immigration and Nationality Act, the section that lists reasons a non-citizen can be removed from the U.S. Those deportability grounds are usually aimed at non-citizens, people on green cards, temporary visas, or with no lawful status. U.S. citizens are not deportable. Instead of trying to deport citizens, this bill says, in effect, that if a naturalized citizen fits one of these new fraud categories, the court handling the criminal case must first strip their citizenship, and then they can be treated like any other deportable non-citizen. On top of all that, the bill includes a watertight retroactivity provision. It says these rules would reach back to misconduct and convictions going all the way to September 30th, 1996. That's nearly 3 decades. So someone who pled guilty to a qualifying fraud offense many years ago, served their time, rebuilt their life, became a citizen in the meantime, could potentially find themselves facing denaturalization years later based on that old conviction if the bill's language were applied broadly. Hearing all of that, it's natural to feel anxious, especially if you are a naturalized citizen who has any kind of criminal history, or if you have loved ones in that position. But here is the single most important practical point. This is a proposal, not a law. Members of Congress introduce a lot of bills every year. The majority of them never become law. A bill being introduced does not mean it has broad support. It does not mean it will pass the committee stage. It does not mean it will be approved by both the House and the Senate. It does not mean the president will sign it. And even if all of that happened, there is still the layer of the federal courts and the Constitution. Many aggressive proposals either die quietly in Congress or are heavily changed before final passage. Others become law but are then partly or completely struck down by the courts. So where does this bill stand in terms of constitutional law? There are at least 2 major Supreme Court decisions that raise serious questions. One is Mayur Afroyim v. Ruskapanrike, which is widely cited for the principle that Congress cannot simply strip a person of citizenship against their will. Afroyim involved a naturalized citizen whose citizenship the government tried to revoke because he had voted in a foreign election. The Supreme Court said Congress does not have the power to take away citizenship as a punishment in that way. Citizenship is protected by the Constitution, and loss of citizenship normally must be based on a voluntary act like renunciation. If you create a system where a naturalized citizen automatically loses citizenship whenever there is a certain kind of fraud conviction, even when the fraud happens long after naturalization, that looks a lot like stripping citizenship as a punishment. You can expect any such law to be immediately challenged as inconsistent with Afro-Yim and later cases that reinforced that principle. The second constitutional concern has to do with equal treatment of citizens. Once someone is a U.S. citizen, the general principle is that they enjoy the same core constitutional rights as any other citizen, whether they were born here or naturalized. Cases like Schneider v. Rusk emphasize that naturalized citizens cannot be casually treated as a second-class group with weaker rights. This bill would clearly treat naturalized citizens differently from citizens by birth. A natural-born citizen who is convicted of the same fraud offense would face criminal penalties, prison, fines, restitution, but would not face loss of citizenship. A naturalized citizen under the bill would face all those same criminal penalties plus mandatory denaturalization. That kind of two-tier system would raise serious equal protection questions. Courts would have to decide whether the distinction is constitutionally acceptable or whether it violates the principle that all citizens should be fundamentally equal in their rights and protections. There are also practical fairness concerns. By removing the $10,000 threshold and writing the denaturalization language in mandatory terms, the bill opens the door to extremely harsh outcomes in cases that, while criminal, are not on the same level as massive organized fraud. You could theoretically see someone who made a terrible but relatively small-scale mistake, still wrong, still criminal, face the loss of everything: citizenship, the right to vote, the right to live in the country where their children were born, the right to return to their home. That doesn't mean fraud should be ignored. It does mean that using the most extreme immigration consequence we have, taking away citizenship as an automatic add-on to a wide category of post-naturalization crimes, is a big step away from how the U.S. has traditionally understood and protected citizenship. All of that said, it's important not to let early-stage proposals control your daily peace of mind. As of now, the Fraud Accountability Act is an idea written on paper. It is the law of the land. If it moves forward, it will likely be debated, amended, and attacked from multiple sides, politically and legally. If some narrowed version did eventually become law, there would almost certainly be lawsuits filed the same day challenging its constitutionality. Those lawsuits would take time to resolve, and during that period there would be uncertainty, but there would also be strong legal arguments available to those impacted. So what should you do right now if you are a naturalized citizen or a permanent resident hearing about this? First, don't panic. Nothing has changed in the law at this moment. Denaturalization is still focused mainly on fraud connected to how citizenship was obtained, not on post-citizenship conduct. Second, if you personally have any kind of past fraud conviction or ongoing investigation, whether immigration-related or not, that is already a serious issue under current law. You should be speaking to a competent criminal and immigration lawyer regardless of any new bill, because existing statutes can already carry significant immigration and citizenship consequences. Third, be careful about where you get your information. Sensational headlines and social media posts are designed to get clicks, not to give you calm, accurate context. Proposals like this one are politically powerful because they sound tough on crime and tough on fraud, but the details and the legal limits really matter. Here at your Immigration Newsroom, I'll keep tracking this bill and others like it. If it moves in Congress, if the language changes, or if any part of it becomes law, I'll explain exactly what's in the final version and who it actually affects. If you'd like a deeper dive into specific pieces of the bill, like the retroactivity language, the definition of fraud, or how it might interact with existing denaturalization doctrine, let me know in the comments. Your questions help shape which topics I cover next. For now, remember this: U.S. citizenship, especially when it was obtained honestly, remains one of the most secure legal statuses in the world. The system does allow for denaturalization in rare, serious cases of fraud, but that power is limited and closely scrutinized in court. New proposals can sound intimidating, but they must still pass through Congress and the Constitution. Awareness is good. Staying informed is smart. Living in constant fear over something that is not yet law and may never become law is not necessary. If this explanation helped you understand the Fraud Accountability Act a little better, consider subscribing to Immigration Newsroom, turning on notifications, and sharing this video with friends or family who are worried about denaturalization and citizenship. Thank you for watching, thank you for your trust, and take care of yourselves and your families.